the matter of the London Sleep Sheet follows into insurance decision with gift and Kingdom of Space and the French states.
Yes, it's going to be quite a long morning, so we'll take a 5-minute break about halfway through.
Very good, my lord.
I'm grateful.
Just first housekeeping matter, timing, Gillespie.
Oh, yes.
The three of us spoke extremely productively yesterday evening, and the states will finish by lunchtime. Quite how Mr. Young and I divide that up remains to be seen. We'll see how it goes, but Mr. Hancock will, in effect, have the afternoon.
Good. Well done.
So if I could please start where well, not quite where I left off last night, because my Lord Justice Phillips asked me about whether the first proposition I was putting under the recast regulation fell within the sort of serious issue to be tried aspect, and on reflection, it doesn't. And the reason I say that is because the question of whether the Section 66 judgment imposed any obligation at all on the states doesn't engage the serious issue insofar as whether or not there is a contract. And under Article 7.1, the only matter which has to be shown to the serious issue standard is the existence of a contract. Everything else constitutes a contractual dispute, which would be within Article 7.1. So it's just the existence of the contract which serious issue goes to. Further to that clarification, the first question under Article 7.1 is, what is the obligation to be performed? And the club says, for the purpose of the recast regulation, we have to work on the basis of this is what the club has said or says, and assume that it's the case. The club says the relevant obligation is one to abide by the English judgments declaring the parties bound to arbitrate civil claims in London, paragraph 166 of its skeleton argument. The second question is assuming the obligation to abide by a judgment is to be performed in a particular place. Where is that place? That is decided by reference to national law. And what the European authorities tell us, and in particular a case called Besix, one doesn't need to look it up, but for the court's note in the transcript, it's bundle B2, tab 22, paragraph 9. What it tells us is that for the purposes of Article 7.1, a single place of performance has to be identified. And if one cannot identify a single place of performance, then Article 7.1 is simply of no application. So to the question of where the obligation is to be performed, it's fair to say there's quite a lot of analysis in both sides' skeleton arguments as to positive and negative aspects of jurisdiction and arbitration clauses. But what I'll be saying is that one has to look firstly at what has been declared in the particular case in order to work out what it is that one actually has to do. But starting from a general proposition in terms of how both arbitration clauses and jurisdiction clauses work, what is the most instructive case from a domestic law perspective is that of the Supreme Court in AES. And my learned friend Mr. Hancock has referred to it a number of times over the past few days, saying that what is important, according to the Supreme Court, is the positive aspect of the obligation to arbitrate, whereas that's not, in fact, at all what the Supreme Court said. So I'd be grateful if we just look at the case briefly, just to set out the correct parameters, and then I'll move on to the analysis of the obligation. And AES is in bundle A3, and it's tab 31. And the first relevant paragraph is, I should say, the facts of the court will be well known to the court. It was all about whether you could grant an anti-suit injunction either under Section 44 of the Arbitration Act or Section 37 of the Supreme Court Act. But at paragraph 1, Lord Manns, giving the judgment of the court, said, an agreement to arbitrate disputes has positive and negative aspects. A party seeking relief within the scope of the arbitration agreement undertakes to do so in arbitration in whatever form is prescribed. The often silent concomitant is that neither party will seek such relief in any other form. And that was then developed paragraph 21, which is on page 1897 of the report. In this paragraph, Lord Manns addresses submissions put by Lord Goldsmith, Queen's Counsel, in terms of the relative importance of the negative compared with the positive obligation. And it said, if I could just ask your lordships to read it to yourselves, but the passage I'm relying on in particular is where it says the negative aspect of an arbitration agreement is a feature shared with an exclusive jurisdiction choice of court clause. In each case, the negative aspect is as fundamental as the positive. And then paragraph 48, there's a sidelined section. And what is said there is that an anti-suit injunction to restrain proceedings abroad is for the purpose of and relates to the negative promise contained in an arbitration agreement not to bring foreign proceedings. And it is that negative obligation not to bring foreign proceedings which I will say is at issue in this case. Now, I don't think we need to turn it up because the court's looked at it a number of times over the past few days, but in case you do, I'm going to just refer to the wording of the relevant declaration in the award or judgment, which is Supplemental Bundle Volume 2, Tab 23. But the wording of the declaratory relief, and I will be saying it's declaratory, was as regards all claims arising out of the loss of the MT prestige and the resulting loss and damage, which are currently brought in Spain by the respondent against the claimant by way of alleged direct public liability under the Spanish Penal Code. 1. The respondent is bound by the arbitration clause, and such claims must be referred to arbitration in London. Now, I know that my learned friend takes a point on the construction of must, which I'll come on to in due course, but not for present purposes. For present purposes, I'm going to assume that this isn't purely declaratory, and it contains an obligation which is capable of performance, because that's the way we have to approach it under the regulation. And so the question becomes, well, how do the states perform that obligation? If one is looking where they are. And what we say is that what it would require them to do, where proceedings are on foot in Spain, which are to be brought in arbitration, is to discontinue the proceedings in Spain. Where do they have to do that? They have to do that and can only do that in Spain. That being the case, the obligation, to the extent there is one, is to be performed in Spain. And really, that's the end of the analysis. It is the negative aspect of the obligation which is being sought to be enforced in this case. And on any view, this Section 66 judgment does not require the states to commence an arbitration. I think it was intimated by my learned friend on, it was either yesterday or one of the days, they've become slightly indistinct, that this case is different by reason of the operation of the conditional benefits principle. It was said that by reason of the sort of offer and acceptance analysis under that principle, because the states had commenced claims and therefore accepted the burden, there became a positive obligation on them to advance claims in arbitration. But we said that's a false analysis. I mean, it just can't be correct. The mechanism by which you become bound by an arbitration clause can't make a difference to the content of the obligation to arbitrate. That's going to be the same whether you're a conventional party or a party under a conditional benefit analysis. And we also say it would be very odd if the law were to impose a positive obligation, a more stringent obligation to commence arbitration on someone who isn't a conventional party to a contract than someone who's a third party to the contract and trying to take the benefit of it. But in simpler terms, we just say this is a negative obligation, that is what is being enforced, that is for what damages are being sought for, performances in Spain. Or in France. It's in Spain.
The concept is one of conditional benefit. You can only have the benefits if comply with the condition, and the condition is starting an arbitration.
The condition is not to commence proceedings abroad. The condition is not to commence.
Yes, but you're not. But sorry, isn't it good enough for your purposes? You don't need to take the benefit.
No, we don't need to do.
You don't
anything.
need to do it. So
We don't have to sue. No.
You don't have to pursue the claim at all.
No. And the claim.
But if you do, you have to arbitrate.
That's right.
So there's no obligation to arbitrate. There's just an obligation that if you do bring the claim, you have to arbitrate.
I completely agree.
Yeah. For my part, I just don't see any difficulty in this at all.
Nor do I. It's really simple. I have to address the analysis put, but in my submission, it's really simple. And it's also, I mean, I'm not going to labour it, but it's also entirely consistent with what the Supreme Court said in the analysis in Marzillier. And your Worship may be sort of familiar with that decision, but I will take you to the relevant paragraph just briefly, because I think it's going to apply to the 7.2 analysis as well, and therefore it's going to save everyone some time if I just show the court. So if I could just, on that front, ask the court to go to, it's in bundle B1 tab 14.
My lord, just for the record, my learned friend calls it Marzillier. I think I call it AMT. It's the same case, but I think there's just a question of reference sometimes.
Yes, we understand.
Yeah.
I was calling it Marzilla until I heard Justice Popplewell say the French the other day. I wouldn't be humiliated. So, the relevant paragraph I'll be taking to Lordship to, if you want to zoom ahead, is paragraphs 25 and 26. But in this case, it was a case where there was a large number of financial services agreements which have been entered into between the claimant, an English company, and its clients, and those agreements contained exclusive jurisdiction clauses in favour of the English courts. And the claimant alleged that a number of its clients had been induced by the defendant, who was domiciled in Germany, to breach their contracts by getting them to commence proceedings in Germany. So the defendant was domiciled in Germany, and therefore the claim could only be brought in England if the harmful event occurred in England for the purposes of Article 8.2. So because the cause of action brought was for inducement of breach of contract, it was analysis under 7.2 rather than 7.1. So we accept, because it's a point that my learned friend relies on to distinguish this case, we accept it's a case under Article 7.2, but it also involved an analysis of the place of performance of the obligations inherent in an English exclusive jurisdiction clause. And to that extent, it is indistinguishable, we say, in any material way from the present case and the operation of an arbitration clause. And so what one sees at paragraph 25 is that the contractual obligation of the former clients was, if they were to sue the claimant, to do so only in England, and the breach of contract was in raising the proceedings in Germany. And then one has paragraph 26, where it said, it's clear that the claimant did not get the benefit of having any dispute with the former clients determined under English law by English courts, but the former clients were under no positive obligation to sue the claimant, which could have no objection if it was not sued. So precisely the case here. They were under an obligation not to sue in Germany or elsewhere than England. The former clients could have performed their contractual obligations to the claimant either by not raising proceedings in Germany or having raised those proceedings by discontinuing them. And we say that analysis applies equally to this case. States are under no positive obligation to arbitrate in London. Club can't object if it's not sued. The states could have performed their equitable obligations by having raised Spanish proceedings, discontinuing them. And certainly from the perspective of France, if we are right on the place of performance for Article 7.1, then 7.1 is of no application, and the court that would have jurisdiction for this dispute is the court of domicile, which would be France, assuming, on this hypothesis, that we are not within the insurance section, but that simply leads to the same route, domicile of France.
Or Spain.
Yes, Yeah, I'm just going to say Spain. I was going to say the same analysis applies.
So France could be sued in Spain.
Um,
Not very likely, but that's the place of the obligation in question.
yes, that's right. It would be.
On your case, yes.
Yeah, sorry, not France, Spain. But subject to Article 7.2 and also 8, the same analysis applies to Spain. So unless Spain falls down on those subsections, this applies. The result is the same. So really, subject to your lordships, that's all I was going to say on the application of the recast regulation Article 7.1.
Yes.
What I was then going to move on to was serious issue to be tried. And I'm principally going to look at that from the regulation perspective, focusing on the question of does a contract exist? Because assuming we are under the regulation, that's probably the most useful way to do it. But I will also just address the threshold question, which spans both the judgment claims and the award claims, in terms of this overarching issue about whether a declaratory judgment can impose a positive or negative obligation, because it's fundamental. And there's the threshold question, which is whether the court should be determining any of these sort of serious issues to be tried questions at all. But we say that, I think, really, to the extent that there is time to do so and the court is in a position to do so, it should do. And really this issue of whether a declaratory judgment can produce a negative or positive declaratory, obligation is so fundamental that it makes sense for this court to deal with it and dispose of it now, which will have a fundamental effect on the pursuit of the awards claims and the judgment claims. So in terms of that overarching question, before I come to the more sort of subsidiary arguments on the club's claim that there are contracts in this case which underlie the judgment claims, if you like. The first question is whether a declaratory judgment imposes positive or negative obligations. I mean, we say that if the awards and judgments contains no positive or negative obligation, there's simply no relevant obligation for the purposes of these causes of action which are advanced in the awards claims and judgment claims. Because even if there is an obligation to abide by something, there is no content to the relevant obligation. There is nothing to abide by. And in my submission, it's perfectly clear that declaratory orders, as a matter of law, do not impose positive obligations or negative obligations. It's clear from Zavarco. It's also clear from a consistent line of cases preceding it, which I'll just refer to briefly. The only question of any difficulty at all, potentially, is whether there exists an anterior or ancillary a contractual obligation which imposes a relevant obligation. And in the case of the awards claims, and this will be principally for my learned friend to develop, it's the implied obligation to honour the award. And there is the reformulation of that implied obligation, which was put forward by my Lord Justice Popplewell, I think on Tuesday, that it's not an implied obligation to honour, but an implied obligation to adhere and not to act inconsistently with. And my learned friend will address that, but it will be said that none of the authorities upon which the club relies for this implied obligation formulate the obligation in those terms. And as a more basic point, I would say, the where an award or judgment is purely declaratory, it's difficult to get around that by saying you do have a positive or negative obligation by reason of some ancillary or anterior contractual obligation. I mean, in my submission, if you want positive or negative relief to come from an award or a judgment, you should have that relief and ask for that relief in your judgment, rather than relying on a separate, unexpressed obligation, which produces, I think, the same effect as a sort of mandatory or coercive award.
Well, you have to imply an obligation out of the declaration, don't you?
Yes, which is, it's circular. Well, I don't know if the right word is circular, but if declarations don't produce obligations, you can't just circumvent that by saying, well, actually, there's an obligation somewhere not to act inconsistently with that declaration. An obligation to act.
It's also very difficult to get the content. Just by way of an example, say there's a dispute between parties as to whether a contract between them exists, whether it came into being, and the court determines that issue and declares as a contract. Is there then an implied obligation to perform the contract because it's been declared there is a contract?
My submission, no.
Well, plainly not. But then take it one step forward. There's a dispute as to whether there's a particular term in the contract, and the court determines that there is such a term. Is there then an implied obligation to comply with that term?
My Lord, no.
It's the same thing.
It's the same thing, my Lord.
But then that's what we have here.
Yeah.
It seems to me.
Yeah, and I agree.
I'm not sure again why there's any real difficulty.
I don't say there is. I think it's quite
No,
clear.
I realise you did.
It's quite complicated.
This is really for somebody else's ears. I appreciate.
No. I mean, yeah, exactly. I mean, I've putting it in quite simple terms because that's just the way I have to address it because otherwise.
It's a point which has been argued quite seriously against you.
Yeah, well, it is. So I have to exactly address it. But I think that it also arises partly out of a sense of confusion about what is the effect. What is the content of a declaratory order, and what is the content of the underlying obligation, which is the subject of the declaration. Now, the order works to declare the existence of the obligation. If you then, as a defendant, act contrary to the obligation so declared, causes of action are going to arise that can be suitable. So there's a contract. The court says that contract exists. Perhaps the court says you also have to do this. You then don't do it, then you've breached a contractual obligation. Not because the judgment imposes an obligation, but because the contract imposes an obligation. Which is why, also the point, there's the arbitrations, and they're saying you breached the equitable obligation to arbitrate. That's the substantive underlying obligation, and that's what the focus should be. And that's really the only cause of action.
And you'd also say, well, I think perhaps we have been over some of this ground, that if the underlying obligation is not destroyed by the operation of the doctrine of merger, then there is no need to create a new obligation because the previous one is still there and can be enforced.
Absolutely right. If there's no merger, then the obligation you're driven to the obligation to honour the award, whatever that would mean, would subsist.
Yes. Okay.
And indeed, that's slightly thinking of my look. It slightly feeds into it because what they say in Savarco is one of the reasons there isn't a merger is because there's no new obligation created.
Yeah, that's right. That's exactly right. Because otherwise there would be a merger. Because the cause of action would merge into the judgment. The judgment is the higher order. It replaces the underlying obligation.
Yes.
Yes.
It's like saying if you declare there's a contract, you no longer need the contract because you've got the declaration.
Yeah, exactly. You still need the contract, in my submission. And I'll come on quite shortly to the decision in Harrianto, which is the sort of basis upon which it was said yesterday that actually every judgment produces there's an implied contract to perform it, and there just isn't. That can be the case in relation to a judgment debt, but simply nothing else. But I just mention it because that's on, I think, my Lord's point to a variation of it. Just on the Savarco point, and just for your Lordship to note, when I said that it's really just the last in a long line of things that have said the same thing, the authorities where a similar thing has been said, at least, perhaps not so clearly and by the Court of Appeal, they're set out at paragraphs 109 and 110 of our skeleton. And on a related topic, when my learned friend Mr. Hancock was taking the court through Germain the other day, there was a footnote, I think, in that decision to the decision of Mr. Justice Beatson and African Fertilisers, and that itself referenced the proposition that a writ of sequestration could be issued off the back of a declaratory order in exceptional circumstances. And I just recalled from last hearing before Mr. Justice Butcher that authority was one called Webster and Southwark London Borough. I said to your Lordship, it's Webster and Sanderson. That's the Webster bit that was right, the rest of it wasn't. But if your lordships want that for completeness, I've brought it along, and I can hand it up. Just in terms if you just literally wanted all the decisions which deal with whether different forms of relief can come out of declaratory judgments.
I expect that'll be. I myself printed it off and have read it, but that may not be so for my lords. It may be helpful for them to have a copy.
Yes, if you've taken the trouble to bring it along, we'll have copies of it, please.
I'm trapped, so I can't move anymore.
Thank you very much.
We don't need to sort of go through it in detail now, but I'll just tell you the potential relevance or not relevance of it. I mean, in terms of reading it, you kind of sort of have to read the whole thing. I think it's a very entertaining decision. It's worth it just for entertainment value. It's an extremely angry judge, and that's really how what happens came about. They wanted to imprison a couple of councillors from Lambeth, Southwark. Before Mr. Justice Butcher, the club relied on this case for the proposition that declaratory orders can be enforced in certain circumstances, and the form of order is no bar to the form of relief. So sort of the Jarmen-Bertley point. And in this case, it was a candidate in a by-election in Southwark Peckham wanted to use a meeting hall to have an election meeting, and the local council refused to allow him to, despite what he was entitled to under the Representation of the People's Act. And Mr. Justice Forbes, believing that the local councillors and the council would do as he asked, made a form of order in declaratory form, saying, in a sense, that basically this candidate was entitled to use the hall, and he thought that would be enough to make the council open the hall to the candidates. Unfortunately, certain councillors refused to allow that to happen, whereupon the candidate applied for committal or a writ of sequestration. And Mr. Justice Forbes gave permission to issue the writ of sequestration. And what came back before the court was whether it was right to have issued a writ of sequestration on the basis of a declaratory order. And where one gets to, and the reasoning in relation to the issue of the writ is on page 709, is that despite all of the cases which he recognised, saying that a writ is only available on a coercive order, Mr. Justice Forbes decided to issue one anyway on the basis of the court's inherent jurisdiction. Because in effect, they'd behaved so badly and there wasn't time to go back and get a coercive order.
Well, that it seems to me, was the critical question. It was the exercise of what was described as an inherent jurisdiction of the court.
Yes.
And the exceptional circumstances were that the application was made at 2:30 on the Saturday.
Yes,
And
in chambers.
The meeting room had to be made available by 4 o'clock. And I think it was the last meeting before the election itself, so that it was simply impossible to see that the rights were given effect to in any other way.
Yeah, exactly. So, I mean, it really is a truly unique case. But also importantly in the case, he recognises and accepts the submission that declaratory orders do not pose negative or positive obligations. And one therefore cannot act in defiance of a declaratory order, and they also cannot be enforced. So that is entirely in line with our submissions and entirely in line with what the Court of Appeal has found in Zvaka.
There's also a feature of the judge's reasoning that he thought the court was misled into thinking that the initial form of order was immaterial.
Yes, that's right.
Page 708.
Yes, that's right. I mean, he was clearly very, very cross about it because the indication had been given by the council's barrister that it would be fine. And obviously on instructions, there was no criticism of council. But obviously then they didn't do what the court expected them to do.
Yes.
You know, there we are. It's a one-off, and in any event, it confirms our position. I'm not sort of going to labour any of this, but there was just one final point, it seemed to me, that was raised by my learned friend, which was on the particular wording of our order on the basis of the word must. And he says that whilst he accepts that declaratory orders generally don't impose negative or positive obligations, this one's different as a matter of construction. I suppose that the obligation, the argument must go. And this did actually require us to do something. but I mean, we say, look, it's plainly obvious that this is just a declaratory judgment, just enforcing, or in the same terms as a declaratory award. And the way I say it should be read is it simply declares that the states are bound by the arbitration agreement, and it further declares the existence of the resulting obligation to arbitrate the non-CLC claims.
You say that must means is under an obligation.
Yes, it declares the existence of an obligation. It's declaratory. It's not a mandatory injunction or an order for specific performance, which it would have to be if it was to have the effect contended for. And just briefly, I mean, context is important here. I mean, you don't look at the sort of wording of the judgment or the award sort of in complete isolation, because all of the debate before Mr. Schaff, Queen's Counsel, and subsequently before Mr. Justice Hamlin was, is there any utility in the relief being sought here? Is there any utility in granting negative declaratory relief? Our answer, yes, there was at that period of time. But
Well, I don't know whether you can go to the argument, because surely the award must stand on its own terms, but there's plenty in the reasoning of the award.
Well, the reasoning of the award itself. Forgive me, that's a better way of doing it. I mean, I suppose if an argument from construction is taken, so you have to look at the background to try and understand what is happening and what factual material background exists which could support the construction being contended for. But my lord is, of course, right. If one simply goes to the award, one will see no mention of it ever being mentioned or requested that there should be a positive or negative form of order, only a purely declaratory form of order. And had it been otherwise, there would have been findings in the judgment about whether you can, in effect, impose, well, whether you can subject a state to an injunction, mandatory performance, given Section 13 of the State Immunity Act.
Yes, well, you can, I think, rely on the absence of any discussion about that point to show that that is not what was being asked for.
In the award, in the reason.
Yeah, the lordships.
Yes.
In which case, just going back to the context of the wording of our declarations, I would just say briefly that they're not comparable to the obligation, or rather the award in Germain. And equally, we're not in the same territory, I would say, as sort of Bertley, to the extent that one can tell from the report in Bertley what the actual relevant order was. And just briefly, in Germain, the award was that the contract shall be performed. I mean, we say that's just obviously positive. That's a positive form of order, not declaratory. But we would also say, in response to the submission by my learned friend, that but it must be declaratory because specific performance wasn't available under Chinese law. That the first point is to note that this is an award, if you like, governed by Chinese law. The obligation which it was reflecting, or rather the claim it was reflecting, was a specific claim under Chinese law called a claim for continuing performance. Now, one sees the basis, and just for your lordship's note, for this Chinese form of relief in the Court of Final Appeal judgment, and the reference is bundle C4, tab 45, paragraph 129. And the court there records that the form of relief is under Article 107 of the PRC contract law, which provides that where one party to a contract fails to perform the contractual obligations, or its performance fails to satisfy the terms of the contract, it shall continue to perform its obligations, to take remedial measures, or to bear responsibility for breach of contract, such as paying damages. So while that may not be an order for specific performance or relief for specific performance, it's far closer to a positive form of relief requiring you to do something, and if you don't, you're going to be liable for damages. It's simply nothing akin to a declaration. So I simply say one cannot construe the award in Germain separately from the cause of action, which it was, if you like, addressing or vindicating. And importantly, in neither Jarmen nor Berkeley did anybody argue, and there's no discussion by the court, of whether declarations impose negative or positive obligations, and whether any form of relief is available following the making of a purely declaratory reward. So in my submission, neither case is of assistance to this court. So really, in summary, we say that where that leaves us is that there's no relevant obligation to sustain the causes of action in either the awards claims or the judgment claims. And so really that's the basic fundamental point which underlies all of this, really. Going back specifically to the judgment claims, the club has sort of 4 strands of argument as to why there is a serious issue to be tried in relation to them. And 3 of those strands relate to whether a contract exists, which is relevant to the regulation analysis potentially. I think, as I mentioned yesterday, the 4 arguments it has, or the 4 bases for its causes of action are, firstly, the proposition that the making of an English judgment results in an implied contract to perform it. The fact that they say there was submission to the jurisdiction in the previous proceedings, which results in a jurisdiction agreement, itself containing an implied obligation to honour the result. And in the case of a Section 66 judgment only, the submission to arbitration can result in an implied obligation to honour, assuming that that award merges from the award into the judgments. So, I mean, we say the analysis is really going to be contractual, or it's nothing. One would have seen in the club's pleading that I showed the court yesterday. There's reference to equity and tort and every other source of law that one can imagine, but it's really only contract where the club advances any relevant authority. And in my submission, what matters is whether the judgment itself or the conduct preceding it creates an implied contract to abide by it. And before I just get to the detail, one just has to also think about, well, what would be the results if that was in fact the case, because they'd really be pretty extensive. So in a case of a declaratory judgment, so leaving aside injunctions, leaving aside judgments which embody agreements themselves, like consent orders, it would result in ancillary obligations being produced which create causes of action in practically every case. Every judgment given of this nature would create obligations to abide by it, but also which could be sued upon. And so these obligations would exist because of judgments, but operate sort of outside of them, and would be independently actionable, and would result in relief, not claims, in the original claim. So really, a judgment would no longer be the end of the road. You just sort of have perpetual causes of action available to the judgment creditor who considered that the other party hadn't satisfied that or complied with the terms of the judgment. So turning to the first argument, which is that these claims are equivalent, and the way it is put is to an action on a domestic judgment. And that's the Harrianto case. And what the club says is that they're entitled to sue the states for damages because, in essence, the judgment claims are actions on a judgment. Now, you can enforce a judgment, or in certain circumstances, you can commence an action on a judgment. And parties sue on a judgment to get a new judgment in the same terms, and they do that, the only situation you can identify them doing it is to avoid the expiry of the limitation period under Section 24 of the Limitation Act, because an action on a judgment is barred after the expiry of 6 years. And if a beneficiary of a judgment or rather a beneficiary of a judgment may wish to get a new judgment in the same terms if there are difficulties with enforcement and they haven't been able to enforce within the relevant sort of 6-year period. And that was what happened in the case of EDF and Mr. Harrianto, because the litigation had been running on so long and Mr. Harrianto had been so reluctant to pay that EDF man were concerned that they were going, their judgment, if you like, was going to run out of time before they managed to enforce. But if I could just ask your lordships to turn up the report, which is, because we do, I'm afraid, have to look at it. It's a bundle C1, tab 14. I mean, this was part of the long-running litigation against Mr. Harrianto, who declined to pay what he was due, and then he settled, and then he refused to pay under the settlement agreement. And EDF, a man, obtained an arbitration award under the settlement agreement, or pursuant to the settlement agreement, and then they forced that as a judgment. So the important point to note, first of all, is that EDF had a judgment debt. And if I could just ask your lordships to go to page 2 of the report.
This judgment is not reported.
No, it's not. It's not.
No. I mean, there are Harrianto judgments which are reported.
They are. They're proper reports, but not this one. This one was, it's obviously sort of, it's quite brief and treated quite lightly. But if I could just ask the court to read from where it says, at the beginning of 1995, which sets out the issue and the problem, down to the end, if you like, of the quote at the top of the following page, the quote from Halsbury's.
Sorry, could you say again what you wanted to read?
Oh, yeah, of course. If you start at the beginning of 1995, and if you go down to the end of the Halsbury's quotes at the top of the following page. So it's that comment, the juridical basis of the claim seems to be that of an implied contract pay, which has been latched onto by the club for the proposition that every judgment produces, or the result of every judgment is an implied contract, that you will adhere to the result. And we say it simply doesn't follow. Obviously, this case is concerned only with judgment debts. And from my research, the only cases where you've had actions on a judgment, firstly, concern judgment debts, so that you can extend the period from enforcing them. And secondly, you get your judgment in the same terms, not different terms, and not for different or other relief. So in my submission, it doesn't follow from the fact that the theoretical, or the juridical basis for an action in debt on a judgment debt is an implied contract for an agreement to pay, but secondly, the result of every judgment is an implied contract to abide by its terms, and simply cannot extrapolate that from this case and what is said.
Well, I see it's simply a decision refusing leave to appeal, and doesn't appear to the court doesn't appear to have given permission for it to be cited, which rather suggests that they didn't think they were making any great breakthrough in jurisprudence. Anyway, there we are.
Indeed, my lord, it's slender authority for what it stands for in itself, but it certainly doesn't stand for the extended proposition for which it is relied on by the club. And just for your lordship's note, so one can see the proposition the way it is put by the club, it's at paragraph 112 of its skeleton. The precise proposition advanced on the basis of this case is that an action on a domestic judgment can be brought in respect to the final judgment on liability based on an implied obligation to honour the judgment. And we say it simply doesn't do that.
Was Williams and Jones a case in which there'd been participation in the proceedings?
Forgive me. Williams and Jones.
On the part of the losing party? Well, I have to say, I myself see some difficulty with a juridical analysis which says there's an implied contract where there's only been a judgment and the party who's said to be bound by an implied contract has not done or said anything in relation to the litigation, which may have been the case in relation to Mr. Harriante. But
well, I mean, there is that. I mean, I did look to see where this concept of implied contract derived, and where I tracked it back to were the authorities relating to the enforcement of money judgments in this jurisdiction, because they were enforced under an implied contract analysis rather than on the basis of comity. And so the cases were Goddard and Gray, I think it's Shisby and Westenholt, and one of the judgments I think is in the bundle which I included just in case it was of interest, is Grant and Eason, where one has the sort of implied contract analysis being used as a justification for enforcing a foreign judgment debt. So that seems to be the genesis of the implied contract analysis.
and it's the promise derives from the original obligation, does it? So that if you create a debt, you impliedly promise to comply with a judgment which recognises the debt or enforces the debt.
Exactly. If there's a debt, you've promised to pay someone something, an amount of money. The judgment then says you've got to pay that person that amount of money. The debt becomes, I think the phrase is, a debt of record. So it's stated to exist, but also the judgment imposes an obligation to pay. But I suppose that judgment simply mirrors the original obligation, which is to pay.
I follow. So it's not an implied contract arising out of participation in the litigation.
No, I don't believe so. No, it arises out of the promise to pay.
Thank you. What about a foreign judgment for damages? Say tortious damages. Is that enforceable through action?
Well, it is now, but in terms of the early cases where there's contractual analysis, they were just concerned with debts. They weren't looking at foreign judgments for damages. I think that came later on, and an implied contract approach. Well, it might work if it was contractual damages, I suppose, but one could then say, well, there's an implied, well, you promised to carry out your contract. But I'm not aware of the cases referring to an implied contract analysis outside of the debt arena at all. Which isn't to say I've searched exhaustively, but I haven't come across anything.
Well, I think foreign judgments for damages were enforced by action, as I understood it, but there was debate about the theory which allowed that, and yes. I thought the law had more or less settled on a theory that there was an obligation arising from a judgment by a court of competent jurisdiction, as distinct from there being an implied contract.
I believe that's where it ended up. But in terms of judgment debts and I suppose the state of the analysis when the implied contract analysis was starting. It wasn't at that stage. The comity, if you like, argument had been rejected by the sort of late 19th century, which is what one's talking about, I think, with Shisby and Grant and Easton. But then everything moved on, and then one had the statutory, the 1920 Act and the 1933 Act, and it all became moot. So it simply didn't matter anymore. But I think that's probably also why.
But it does still matter in relation to some jurisdictions, such as the United States, for example.
Yeah, no, that's completely fair.
Yeah. Okay.
The second contractual basis is the voluntary submission in previous proceedings analysis, and for the court to note that that's articulated at Club Skeleton at paragraph 113. In short, what the club says is that, well, the states participated in the proceedings in 2013. Not only did they participate, but they issued their own applications under section 67 and 72 of the 1996 Act. And as a result, and as the Court of Appeal found, they thereby accidentally and involuntarily submitted to the jurisdiction of the court. They took a step in the proceedings, therefore they lost immunity by reason of section 2. They'd lost immunity by reason of section 9 anyway, so it didn't much matter. But they were found to have submitted to the jurisdiction. And what the club says is, well, that action by the states, in effect, in participating and in issuing its own applications, constituted an implied jurisdiction agreement, and also out of an implied jurisdiction agreement comes an implied obligation to abide by the result in the proceeding, which you've submitted to. We say neither of those submissions holds good. And first, just to be clear about the conduct that we're talking about, and I don't think we need to go through the detail of the Court of Appeal decision, but for your Lordship's reference, the decision of the Court of Appeal in Prestige number 2 is at bundle A4, tab 47, and the discussion from Lord Justice Moore-Vick goes from paragraph 47. And it records that my learned friend, Mr. Hancock's submission at the time was that even if the states hadn't lost immunity by their participation, they're defending the Section 66 proceedings brought by the club, they had lost it by reason of issuing under 67 and 72. And the Court of Appeal upheld them in that submission. And what the states had argued at the time was that, in effect, a compressed timetable had been imposed because of the club's application for expedition, because it was all terribly urgent. And the states felt that they had to pursue their substantive objections concurrently and together with immunity, or risk losing them. And what Lord Justice Moore-Vick said in its paragraph 51, for your Lordship's notes, I'll just read it rather than turning it up. It says, I can well understand that Spain felt itself to be under pressure to agree to an early hearing and did not want to allow its argument on the arbitrator's jurisdiction to go by default. But in light of the club's request for expedition, it had to decide what course to take. It took a step in the proceedings other than for claiming immunity, therefore it is deemed to have submitted to the jurisdiction. So that is the conduct which the club says constitutes the implied jurisdiction agreement. Now, the authority relied upon for the proposition that one can have an implied jurisdiction agreement as opposed to an express jurisdiction agreement was the Privy Council decision in Vizcaya. If I could just ask your Lordships to turn that up, it's bundle C3 34. And the relevant paragraphs I'll be going to will be from paragraph 55 on page 197 of the report. One doesn't need to read all the sideline sections for present purposes. But this was a case which arose out of the Bernard Madoff Ponzi scheme, which which your lordships will be familiar with, no doubt. And the trustee in that case, Mr. Pickard, went around the world trying to recover the monies from the people who'd been paid out under the Ponzi scheme. And the trustee in bankruptcy sought to avoid payments made to investors in this case. And in this case, the trustee obtained a default judgment in New York and sought to enforce it against the defendant in Gibraltar on the basis that the defendant, which was a mutual fund, had submitted to the jurisdiction of the courts of New York, either by its actual physical presence in New York, or, importantly for present purposes, it had agreed on the basis of contractual documents, which documents included a New York choice of law clause. The issue arose in Vizcaya because there was division in the authorities previously over whether an agreement to submit to the jurisdiction, or rather an agreement, a jurisdiction agreement, could be implied, or whether it had to be express. And the Privy Council, with Lord Collins giving the advice of the board, held that whether a judgment debtor had agreed to submit to the jurisdiction of the foreign court depended on whether he consented in advance to that jurisdiction, and there had to be actual agreement, but it could be express, inferred, or implied, either as a matter of fact in the relevant contract, where a term could be implied from the circumstances, or by implication of law. And at paragraph 55, he says that the agreement does not have to be contractual in nature, but the real question is whether the judgment debtor consented in advance to the jurisdiction of the foreign court. And at paragraph 58, he then sets out various factors as to when one might infer such an agreement, none of which are relevant here. And he went on to decide in that case that there was no implied submission based on the experts' evidence of New York law. Now, in our case, in terms of previous, if you like, participation in the 2013 proceedings, we say that participation, if you like, accidental submission to the jurisdiction, cannot be reasonably construed as the states consenting in advance to the jurisdiction of this court. This was an issue, or an issue very similar to it, was considered by Mr. Justice Henshaw on the club's Section 18 application. Mr. Justice Henshaw didn't agree, I don't think he agreed with Spain on anything, but this was the one point he did agree with Mr. Young on. The issue was slightly different because on the Section 18 application, the club had argued that Spain was not immune under Section 9 of the State Immunity Act because it had entered into an agreement by participating back in 2013 to be bound by the arbitration clause in the club rules. So they weren't saying you're bound to agree to the jurisdiction of the English courts. They're saying you're bound to uphold or comply with the arbitration clause. And they also argued that that agreement itself was subject to the arbitration clause. Thus, the alleged contract was an implied agreement to comply with the clause should Spain lose the Section 66 application. And that's obviously similar to the position put here because it said by participating back in 2013, the states agreed that should they lose before Mr. Justice Hamlin in the Court of Appeal, they will abide by the result, i.e. to be bound by the jurisdiction agreement. Not the jurisdiction agreement, forgive me, the obligation to arbitrate. Mr. Justice Henshaw, and it probably does make sense just to turn this up. It's at paragraph 92 of his judgment, which is in the second core bundle at tab 37. It's page 515. So, dealing with this particular argument, Mr. Justice Henshaw concluded on the balance of probabilities, in this case, because he was dealing with immunity, that Spain's conduct in participating in 2013 did not give rise to an implied contract. And he says, at 92, I see no reason to infer that by taking steps in litigation with a view to resisting enforcement of an arbitration award, a party is making a contractual offer to abide by the result. It may thereby be submitting to the jurisdiction of the court, but that is a different matter. The notion that by taking an opposing position in litigation, a party can be regarded as entering into a fresh contractual relationship with the opposing party seems counterintuitive, and the club cited no authority in support of it. I suppose the club would say, well, we have now cited authority, and it's Vizcaya, but in my submission, you cannot infer a jurisdiction agreement, still less an agreement to abide by the result of the litigation, from the fact that you participated in the litigation and ended up submitting to the jurisdiction of the court. And we say that Mr. Justice Henshaw's reasoning applies equally to the present position. It's only if the states are wrong about their participating back in 2013 not constituting an implied jurisdiction agreement that then one has to go on to consider the next limb in the club's argument under this ground of whether the jurisdiction itself carries with it an implied obligation to abide by the result of the litigation.
Has the club appealed on that ground?
No.
My lord, no. I believe an argument is taken by my learned friend in his skeleton argument that it doesn't constitute initial estoppel because there were two bases for the judge's decision. They couldn't appeal by reason of one of them, and so the fact that this has been found doesn't operate as an issue estoppel. I mean, I'll let Mr. Hancock make that point, but there's no appeal.
Well, there is a respondent's notice, but at this point doesn't seem to be in it.
It's not in it. As far as I know, it's not in it.
Yeah, okay.
So in terms of the further proposition the club would need to establish, the implied obligation to abide by the result, the authority it relies on for that is a case called Atlantic Electricity and Zurich, and it's at bundle C2 tab 19. Now, I'm not going to, it's a Privy Council decision, I'm not going to take the court to it because I don't think we need to, because all this decision does, is to restate basically the findings in Bremer and from Besti that a submission to arbitration implies an agreement to perform the award upon which will lie an action for non-performance. And the proposition that there's an implied term arising out of either the arbitration agreement or the submission to arbitration, that the parties will abide by the result. So it's just the same proposition which the club relies on in relation to the awards claims. Bumbesti, Bremer, that line of authority. And the club says this should apply to a jurisdiction agreement as well as an arbitration agreement. And I know I said yesterday that jurisdiction agreements and arbitration agreements were indistinguishable. But in my submission in this respect, they are not, because there's a fundamental difference between an award and an arbitrator coming to a decision which is embodied in an award, and the court hearing proceedings, trying them and coming to a judgment. The implied contract and the implied contract to honour the award is necessary for arbitration, because without it, there's no inherent power to enforce, if you like, an award. That's why it's required. Where you have a judgment produced by a court, allocated jurisdiction under a jurisdiction clause, the judgment is enforceable without any further ado. There is nothing further. There is no agreement of the parties required in order to render it enforceable. It's a judgment of a court of unlimited jurisdiction, and it has effect by that reason alone. So it's simply not. There's no requirement for there to be an ancillary implied contractual obligation to adhere to the result. one simply cannot read across from the arbitration cases an equivalent obligation into a judgment. And there's no authority whatsoever which is cited by the club to support the proposition that an obligation equivalent to that relating to the fulfilment of the awards applies to judgments. So we say no implied jurisdiction agreement, no implied obligation to abide by the result of the obligation, and we also say that that disposes of the club's alternative judgment claims, where they say that, well, if the obligation to honour the award merged with the judgment, there must be an obligation to honour the judgment, and they rely on the Bombesti for that proposition, and that's the only authority they rely on for that proposition. And we say there's just simply no equivalent for a judgment. It's the same submissions I've just made. Where you have a Section 66 judgment or any judgment, you don't need, and there is no authority for the proposition that there's an implied obligation to comply with the result. Now, my lords, I'm making quite good time. I only had one more topic to address, which was, would the court like me to break now and address the topic afterwards?
Well, go on to about past, and or stop before past if that's the case, but that's about
No, I'll be done by past, and then
all right.
leaves Mr.
Well,
Yard.
why don't you complete them? Perhaps then we'll.
Very good. The final basis upon which the club says that the judgment claims work is that damages are available for breach of a court order. Now, the distinction between this and the previous arguments I just dealt with is this isn't a contractual analysis. So actually, this isn't really relevant to the judgments regulation analysis at all. It would simply be relevant to serious issue retried, common law basis, if we're outside of the judgments regulation. And the argument goes that a litigant may be liable to compensate the opposing party for breach of an order or judgment simply by virtue of having breached the order or judgment. The club says, paragraph 116 of its skeleton, this is a contentious area of law and therefore this court shouldn't decide it. And the decision the club relies upon is that of the Supreme Court in the BTA Bank and Krapanov case. In that case, the defendant was attempting to convince the Supreme Court that not only did a contempt of court not give rise to an action in damages, but that there was a rule of public policy which precluded such an action, a cause of action. And in addressing that submission, which the Supreme Court rejected, saying there's no such rule of public policy, the Supreme Court noted that there was a certain amount of authority to support the proposition that there could be a right to recover civil damages, damages for contempt of court. And it cites a number of, I think it's probably all of the authorities, and just for your lordship's notice, at paragraph 19 of the Supreme Court judgment, which are relied on by the club. One doesn't need to go to them. They are all fairly old authorities, indicating that where the court is using its coercive powers and a person doesn't comply with them, in certain circumstances, damages can result. The Supreme Court, and its, for your lordship's notice, paragraph 22 of the judgment, accepted that there were powerful dicta, including at House of Lords level, against there being a right to damages arising out of conduct constituting a contempt, or at least breach of an injunction, but accepted that the last word had not necessarily been said on this subject, and that is the comment in the Supreme Court that is relied upon by the club. It says it's not a closed area of law, and therefore it's arguable here that a right to damages arises out of our declaratory relief. So my starting point is I accept it's an open question whether you can get damages for breach of a coercive order. But the states say that there can be, and there is simply no authority at all for the proposition that damages could lie for breach of a declaratory order, even if that were to make some sense or be a coherent position in its own terms, which it isn't. I should also say that the Supreme Court, in its page 750 of the report, said there's ample authority for the proposition, which is perhaps obvious, that breach of an order of the court is actionable where it gives effect to an underlying private law obligation, which is itself actionable. And I'm just going to come on to that because it's relevant in the context of the Supreme Court's subsequent decision in aspect contracts. But what was really being said there is that where a party or where parties enter into a contract, and that is then reflected in the terms of an order, such as the consent order or undertakings which are given to the court, those can, in certain circumstances, take effect as contracts, and breach of them can result in a liability for damages. And we accept, as well as the fact that it's an open question in the law whether an injunction can produce damages, that if you breach an obligation embodied in undertakings or a consent order, that can, in certain circumstances, also produce a right to claim damages. But we say we're just not in that territory at all. On the present hypothesis, what the club is seeking to do is to sort of justify the existence of an obligation to abide by the Section 66 judgment. And it's relying on the effect of the judgment itself and not, crucially not, an underlying contract and not the obligation to arbitrate, which has been declared in the judgment itself. And the club simply can't show that it's the judgment itself, as opposed to the right it declares, that gives it any right to damages. And we say it just can't get home on that, even on an arguable case basis. And just to make good the proposition in relation to declaratory relief, the Supreme Court considered the potential effect of declaratory relief in the case of aspect contracts and Higgins. This will be the final authority I go to, but I will just ask the court to turn that up. And it's at bundle C3, tab 31. Now, this was a case arising out of the adjudication of a construction dispute under Section 108 of the Housing Grants, Construction and Regeneration Act 1996. And your lordships will be aware that that Act provides for a sort of speedy and provisional form of dispute resolution, which the parties can either accept or can subsequently challenge in court, which is the final arbiter of the matter. But the adjudicator in this case decided that the claimant, which was called Aspect, had breached its duty of care and had to pay a sum to Higgins. An Aspect, in fact, paid that sum. But some years later, and when Higgins's cause of action for breach of duty had become time-barred, Aspect brought proceedings seeking a final determination of the provisional award which had been made by the adjudicator. And the relief it sought was a declaration that it was not liable to pay money to Higgins and, crucially, an order for the repayment of the amount it had already paid Higgins. Higgins countered, saying that aspect of Aspect's cause of action was time-barred. And the Supreme Court held that it was a necessary legal consequence of the scheme under the 1996 Act, the Regeneration Act, that implied into the parties' contractual relationship a right to recover any overpayment which the adjudicator's provisional decision had led to, once that was finally determined by the court. And the Supreme Court found that the right to repayment arose by either contractual implication or an independent restitution obligation. And it's really sort of fundamental to this case that the Supreme Court found underlying substantive rights. Now, the Supreme Court decided that Aspect wasn't time barred from recovering the money because time only ran from the date of payment and the 6-year period hadn't expired. And the Supreme Court decided that the parties in this case had underlying rights and liabilities which differed from and were separate to the adjudication decision. And Aspect argued its entitlement to recover arose from the point of payment. Now, in response to, Higgins argued that the claim was time barred and the Aspect could no longer seek relief from the court. It couldn't ask any longer for repayment. And the Supreme Court said that to treat Aspect's remedy as, actually, let me start again in terms of what Higgins asked for. Higgins, their purpose or their aim was to say Aspect's claim was time barred. And the way that Higgins thought of doing that was to say, right, Aspect's only entitlement is to declaratory relief. To the extent it wants to get any money back, it has to rely on the power of the court to grant consequential relief by way of an order from repayment. If I could just ask your lordships to look at paragraph 18 of the report. And if I could ask your lordships to read paragraphs 18 down to the bottom of 20 with a particular focus on paragraph 20, I'd be grateful. So, Lord Justice Mance said, given the judgment of the court, that consequential relief depends on the existence of a cause of action. One only gets consequential relief following a declaration if there's a substantive right to sustain it. He is not suggesting that a claim for a declaration could be accompanied by consequential relief ordering a payment to which there was no independent right. The point, therefore, was that if Aspect had not had a substantive right, it would not be entitled to substantive relief by reason only of it having obtained a declaration from the court. Declaration does not generate the right, the underlying right, creates the right to seek consequential relief. And so we say on the basis of, which is made perfectly clear by Aspect contracts, that, and it's consistent with the fact that declarations don't produce negative obligations or positive obligations, that one cannot claim damages arising solely out of purely declaratory relief. To the extent one can do it, one has to sue on, or invoke, if you like, the underlying substantive right, either declared in the declaration itself or subsisting as a matter of law and independently. And so really, therefore, we say that even if the club is right, that it's an open question on the law, that you might be able to get damages for breach of a coercive order. Nothing said by the Supreme Court in Krapanov alters the basic proposition that one cannot get damages on the back of a declaratory order, which doesn't require anybody to do anything or not to do anything, and equally doesn't itself generate a right which could otherwise justify the award of damages. And so really as a result of that, we say there's no seriously arguable aspect, seriously arguable point on this aspect of the case either, which is the last basis upon which the judgment claims are put. So unless I can assist your lordships further, that was all I was proposing to say.
I've got one question which has been puzzling me. That is, what is the correct name of your client? According to Professor Google, it would be the French Republic, in line with the postage stamps. And slightly to my surprise,
French state.
French state is sometimes used to refer to Vichy France. Perhaps you could find out how you would like to be referred to in the judgment.
I will check, but I will check and take instructions, of course. But I'm tolerably sure, this having been checked, I think perhaps several hundred times to date, just to check we're not causing offence, that it is the French state, yes, which takes a different line to Spain, which is the Kingdom of Spain. But I will seek
yes,
instructions.
All right. Well, subject to that, we'll just take 5 minutes to give everyone a chance to stretch their legs.
They're not listening.
Sure. Well, it's funny, that same thought has crossed my mind. But I'd assumed that it had been debated at the highest level.
I think it has, because there's a lot of stuff the first time round about the Kingdom of Spain, whether it was the same as the Spanish administration.
It was a long time to try and say that it was actually the department.
Yeah.
That was a big issue.
It was a big issue for a little while. And so we checked with
But l'état c'est moi, that's the answer, isn't it?
yeah.
Monsieur Macron would do it on the football field, according to the science.
Probably why it doesn't work.
Yes, that may very well be.
Yes, now
It's interesting.
so it made my pacing. But I knew this is basically, if I'm given enough time to do something, I can pace it perfectly. If I'm shoved into, having to make decisions about whether,
But I'm sure it's a
before
combination.
Butcher, it was just.
I'm sure it's a combination of things, but
I find it a bit easier on my feet when I've got people and I can actually judge it rather than doing it into a camera.
I'm sure that's right. I'm sure that's right. You can do it. You don't have to look, do you? You are, to some extent, getting in your peripheral vision, so you're seeing how it's going, but you're actually concentrating on something else when you're in the camera. You are actually concentrating on the camera rather than seeing it in your peripheral vision. It's weird.
Exactly. You can't always see everyone and what they're doing. You lose quite a lot of the sense of sometimes what's happening. Whereas actually, if you have people in front of you, you just read them, and you should read them.
Yeah.
Which is what you miss quite a lot with remote hearing. I just felt very clear today. Sometimes you reckon things are very clear to me now.
The one thing is that you're not being asked to learn the points which is famous, the critical and harmful points, because you're aiming.
And today was the point. I just put the point out.
I'm
sent me a load of propositions and addressing them how much, which I don't like. So basically, I'm just taking that.
Oh, well, mine's falls on quite a lot.
It seems to be the last of dealt, so I don't have to rely on Tim for anything. Whatever he says. But I'm fed up with that.
We'll have a discussion in due course.
I am better if I can just do it myself. I reckon it'll be dictated by timing. And we're first. See how much time I've given you?
No, I thought you were absolutely bloody brilliant. As well as stealing my thunder on declarations.
I thought I'd just try and draw it together whilst leaving you.
With next to bugger all to talk about, yes. I think that's probably, that's roughly what I thought you were up to.
Yeah?
Yeah. I will not be very long.
I do myself. I do know what I do myself. Never touch on it again. Yesterday. Conking out like no longer. Pop-tarts are not good. For one.
It's a long time since I had a pop-tart.
It's a long time since you've had a Pop-Tart.
I had one yesterday at lunchtime because I was desperate. And that was a mistake. I will never do it again.
I'm not sure I've ever had a Pop-Tart.
And my niece came to stay and she's like 23 and left a box of Pop-Tarts. At 6 o'clock in the morning.
All right.
My lords.
Yes.
Apart from two, I hope, short preliminary observations, I was, and to a certain extent still am, planning to deal with 4 principal topics. The first is one which my learned friend still not has dealt with, is the legal impact of declarations. I have a few. I had more to say, I think, but as a result of what she has said, I think what I was going to say can be significantly reduced. Then there are 3 Spain-only issues. What I'll call subrogation and injured parties, which is, broadly speaking, to be found in paragraphs 146 to 155 of our skeleton argument. And that arises only in relation to the application of section 3 of Brussels Recast. Then there is, the next one is counterclaims, in inverted commas, which is paragraphs 158 to 161, and 178 of our skeleton. That relates to whether the present actions are counterclaims in the enforcement appeal, and it arises in 2 contexts. One is section 14, Article 14.2 of Recast, and that's, of course, dependent upon the matters relating to insurance, and it also arises in relation to Article 8.3, more generally if it falls outside. So, and possibly different considerations apply. And they are in any event considerations which are different from those which we've considered hitherto in relation to state immunity, as I will briefly say. And the last point is Article 7.2 of Recast, dealing with tort delict and quasi-delict, which is paras 178 to 181. And that is, broadly speaking, what I'll call the harmful event issue. So one has always got to ask oneself, quite at any particular point, what is the set of jurisdictional assumptions which we are making. But I hope that will explain where I am going. A couple of just short preliminary observations, and I hope they are very, very short. My learned friend, Mr. Hancock, referred yesterday to the fact that both parties invited Mr. Justice Henshaw to deal with the substance of the Section 18 application along with the service applications, which was specifically before him. That was an attempt to be efficient and not to misuse court time. But for the purposes of the present appeal, which is, I would respectfully suggest, related specifically and only to the question of service, which will actually come down to serious issue to be tried, in my respectful submission. It may be important just for the purposes of identifying that which is available to me to raise before your lordships, and that which, because of Section 18.5 of the Arbitration Act, isn't, because the learned judge didn't give leave. So I would respectfully suggest that the pragmatic, sensible, and time and cost saving exercise that we engaged in should not be held against us on an overzealous application of the Section 18 leave requirement. And therefore, I don't need to the judge's leave, but I obviously, so far as there is a specific Section 18 issue, I didn't have leave, and I can't raise it before your lordships.
Well, your pragmatism, however commendable, can't confer a jurisdiction on this court if he doesn't have one.
Without question. But the question is whether our pragmatism deprived us of relying upon a jurisdiction which you otherwise would have had in relation to a service application. I hope that's fair. I'm very anxious to be very precise upon what I can raise before your lordships jurisdictionally and can't. But the one thing I would ask your lordships is to take a view of the leave requirement in Section 18, so as not to exclude an appeal on the service issue, which doesn't require leave. And I had a look at the Manchester City case, my lord. I would respectfully suggest it's the same sort of consideration. But I say no more other than that I fully respect the fact that I need leave in relation to specific Section 18 points, and I cannot raise them. And I do not do so. The second point is in my learned friend Mr. Hancock's skeleton, nearly at the very end, paras 197 and 198. He refers to the point which I think I alluded to earlier in relation to state immunity, as to the interplay of Section 9 under the State Immunity Act and the jurisdiction of the arbitrator. And 197 and 198, what Mr. Hancock said is these issues give rise to two short points of procedure which arise if the Court of Appeal determines the jurisdiction of the arbitrator in the context of Section 9, as I would urge your lordships to do. In this event, there are two possible outcomes. If the Court of Appeal determines the arbitrator does have jurisdiction, there is no question as to whether the arbitrator was correctly appointed, and that's plainly right. It's the second stage. If Spain's challenge to the order for service out and the Section 18 order necessarily would have to fail. But then, two, if the Court of Appeal decides, contrary to the club's primary position, that the arbitrator does not have jurisdiction in the context of a Section 9 of the State Immunity Act, it's submitted that it doesn't mean that the order giving permission to serve out was wrongly made, since the test on that application was a serious issue to be tried, not the balance of probabilities, and Spain cannot challenge the order appointing the arbitrator under Section 18. However, going on to para 198, if the latter of these two possibilities is what the Court of Appeal decides, i.e. the arbitrator does not have jurisdiction, the practical result will be that unless and until the decision is overturned, it will bind the arbitrator or the High Court such that it will be found to find the tribunal does not have jurisdiction and will dismiss the club's claims, and the club's answers are the same. Now, there is just the oddity that my learned friend alludes to, that there could be a determination that the arbitrator does not have jurisdiction at one level but not at the other in terms of the test to be applied. And the point is a point that I've made earlier, that it would be wrong to arrive at a conclusion which would effectively permit the club to maintain an issue estoppel in the arbitration, and then to say in any Section 67 application that Spain might issue, or indeed France might issue, that would amount to a submission to the jurisdiction for the purposes of Section 2. And as long as your lordships have that well in mind, I don't think it matters. I would urge your lordships to decide the issue of jurisdiction finally one way or another, and thus to dispel any lingering doubts that may exist. But that's all I wish to say on that. It's in a sense, it's a repetition of a point I've made. Now, my learned friend also yesterday, just in passing, referred to the Alexandros tea. It isn't before your lordships. I had thought about getting the clerks to photocopy all of the relevant judgments, but I'm afraid in the time available that was not possible. But may I just comment briefly upon what my learned friend said, because he was suggesting that there was a Greek judgment that was on the verge of being enforced in the UK under the it might have been Brussels 1, but certainly possibly Brussels Recast. That was wrong. And can I briefly give you an account of the Alexandros tea? If you want to look it up, it's in Mr. Justice Burton's judgment is in 2012, 1 Lloyd's at 162. But it involved the sinking of the Alexandros tea. And there was a claim against Hull underwriters for a total loss. There was also a cargo claim. The defence of the underwriters was that of scuttling, relying in particular upon a statement of the boatswain. There was, however, a settlement agreement of the sinking of the insurance claim, which settlement agreement involved a lot of parties and had an express exclusive jurisdiction clause in it. That's jolly important. Following the settlement agreement, the underwriters paid pretty much the full claim. Now, after that settlement agreement was made with its exclusive jurisdiction clause, and after the payment of the insurance proceeds, the owners, they're by then a non-ship company, and a number of associated entities in the same broadly group of owning companies, began proceedings in Greece for criminal defamation and bribery of the boatswain to give false evidence about scuttling. And your lordships will doubtless know that in Greece, because of the position that shipping has in Greek economic and social life, that they were serious matters. It was described as, I think, by Lord Justice Toulson, the Court of Appeal, as akin to malicious falsehood. But the criminal defamation claim carried a potential for civil liability, much as indeed in the present case there was an attendant civil liability upon the doing of a crime. And a claim was made for about $150 million by all the members of the ship-owning group, plus the managers, because they said, all of our losses, which we have suffered recently, as it happens, it was late 2008, but that's neither here nor there, were due to the defamation which has been perpetrated upon us. And so the other owners and the managers sued for what they said was damages resulting from that criminal defamation. There were a number of defendants all over the world to those proceedings. They included Hill Dickinson and Mr. David Foxton, as he then was. Mr. Foxton had signed the defence in the insurance claim alleging scuttling. And I happen to know that I was on the verge of being joined as a defendant because I had signed a defence in the the claim in the cargo action, relying upon what the underwriters had alleged in the sinking action, namely scuttling. As it happens, my joinder as a defendant never came about. But there was no judgment in Greece, absolutely wasn't. There were just proceedings. Thus, there was no attempt to enforce anything, although the risk was a risk worldwide. And it would have been a risk to Mr. Foxton, for example, travelling to France or travelling to Greece or travelling anywhere else. I seem to recollect it was a similar sort of risk in a different context that my Lord Justice Mayles had in relation to going to Texas many years ago. The same.
Your memory is better than mine.
In relation to the Pilkington glass case, my Lord. Brownswood, you don't remember it. Anyway, but there was a risk all round the world, but it wasn't a result of an existing judgment, nor was there any attempt to enforce an existing judgment in England. And what happened was that Mr. Justice Burton made an interlocutory order in an action against the owners brought jurisdictionally under the express jurisdiction clause for the owners to establish a fund out of which there could be an indemnity as appropriate. Now, so there was no question as to whether the English court had jurisdiction in relation to the settlement agreement, because that's what the settlement agreement provided. Now, as it happens, the owners did not establish the fund, and proceedings were commenced for contempt of court, which ended up succeeding. And the action in Greece was then discontinued or withdrawn. Now, there was no question about where the harmful event occurred or whether there was any enforcement or lawful enforcement in England of a Greek judgment. So actually, the Alexandros T is of no relevance. If your lordships want to look it up, please do, but I hope I've given a fair account. And as I say, having once been nearly a defendant in the case, I feel reasonably confident in my description of it to you. Now, my lords, with those three preliminary observations, I'm going to turn to the four principal points, the first one of which was declarations. I think my learned friend Miss Dillnot and I may have been slightly at cross purposes. So I burnt a little evening oil, and I have produced, I wonder if I could ask your lordship's associate, excuse me.
It's appeared magically on.
Oh, that's wonderful. What I have sought to do is to reduce the law to 10 propositions, which I thought, having it written down in advance, would assist your lordship so that I don't have to read it out at dictation speed. And passed on. I hope it's of some use. I'm slightly more confident about them because they passed the withering gaze of my learned junior, who has passed, they say they pass muster, but they are the submissions which I submit represent the law on the subject. I was just wondering if you want just to cast your eyes over them so that if there's any point arising. But I hope, although it's treading on Miss Dillnot's toes, I hope it's going to be a useful exercise.
I'm not inviting you to take us to it, but I think in Riem is a case we haven't seen it. Can you just tell us where that is in the bundle?
I was going to do exactly that, my lord. It's C3 tab 32. I can actually give you all of the references.
Well, we've looked at all the other cases.
Yes, it's C3 tab 32.
Yes, thank you.
I was anticipating showing you each of those cases briefly, so as. But, I hope that's useful.
Yes, thank you.
One thing I might just mention is it's really in relation to the brackets at the end of proposition 6. Because I think my Lord Justice Popplewell proposed the possibility that there be some sort of implied term that a party would not act inconsistently with a declaration. In effect, it would be an injunction. And I think it was also something that was raised by my Lord Justice Phillips in passing this morning, where he said that one would have to imply an obligation into the declaration of that sort. Now, the problem in this case for Mr. Hancock is that that is simply unsustainable in the face of Section 13 of the State Immunity Act, which says that no injunction or specific performance can be granted against a state. And so the very implication which my learned friend, Mr. Hancock, seeks, and was identified by Lord Justice Phillips, is something which is legally impossible for the court to do. So even were it the case that the way that my Lord Justice Popplewell proposed it, which was never a way that had been relied upon by the club, it might exist in other cases. It cannot do so in the present case because of Section 13. It would be so. It is a material problem in the present case. But in my submission, everything that Ms. Dilnot said this morning about declarations is adopted by Spain. And one notes that the passage which has been cited in the state's skeleton argument, the extensive passage from Zamir and Wolfe, was a slightly more extended passage which was referred to with approval by the Divisional Court in the Civil Liberties case, which is at Bundle C3, tab 37. And the point was made, I don't know if you probably don't need to turn it up, but the point was made by Lord Justice Singh that non-coercive declarations, this is 37, page 495, non-coercive declarations have a particular value short of being injunctions, because at paragraph 52 he says there is a constitutional convention that the executive will comply with the declaration made by the court even though it does not have a coercive effect. See per Lord Bridge, Harwich in Factortame. Now, you will all know that the declaration as a remedy took off, broadly speaking, in the or took off as an important remedy following Annis Minnick and the Foreign Compensation Commission in 1968, and it developed into what then became JR in the 80s. And declarations have a particular function in administrative law, where it is probably their prime focus. And the very important point about declarations in administrative law is that the Crown, who is usually at the receiving end of it, cannot have coercive orders made against it because of the constitutional convention. But what you say about declarations is applicable across the legal spectrum, not just limited to administrative law. And if perchance you were to say, well, a declaration can generate a legal obligation which is itself coercive, that would actually undermine pretty much its entire status in the administrative law area of practice. And what Lord Justice Singh goes on to do, at paragraph 53, he says, it's important to note that what is said by Zamir and Wolfe at para 107, while the defendant is assumed to have respect for the law, justice does not rely on this alone. A declaration by the court is not a mere opinion devoid of legal effect. The controversy between the parties is determined and is res judicata as a result of the declaration being granted. And that is its real impact of a declaration is, as it were, preclusive of certain consequences. And that is why, when the learned arbitrator, Mr. Schaff, was considering the question of the exercise of his discretion to grant a declaration, he noted, this is supplementary core bundle, page 389, your lordships, doubtless have it in mind, but at paragraph 108E, he said, fifthly, Mr. Hancock elaborated on this latter point by explaining that the declaratory relief sought from the tribunal was sought for defensive purposes. That was, I think, probably the point that was referred to by my Lord Justice Mayles. Namely, to give rise to an award which could be registered as a regulation judgment and which could then be used to insulate the club's assets from any inconsistent judgment which may subsequently emanate from the Spanish courts. He was considering the possibility that an award from the Spanish courts might still emanate, and that therefore Spain would have continued to proceed. The award is not sought to provide the Spanish court with any form of advisory opinion on the position under English law. And over the page 109, the obtaining of declaratory relief would provide the club with an important safeguard in the event that the Spanish courts seek to uphold the right of direct action and render the club liable. So the function which is of a declaration, which is recognised by Lord Justice Singh in the Civil Liberties case, and the very purpose of the learned arbitrator in making the declaration was to provide a defensive statement of the law, a defensive statement of the position. Thus, not only was the express purpose of the declaration defensive, which is consistent with all of the other law on declarations, it was distinctly not intended to be coercive. And coming back to a point I made earlier, Mr. Schaff cannot be assumed, or it cannot be implicit in Mr. Schaff's order that he intended it to be coercive, because that would have offended section 13, at least when it got converted into a judgment. And I accept there's an argument where my learned friend raises in the arbitration that the power of an arbitrator is not limited by section 13. In my respectful submission, everything that my learned friend Miss Dilnot has said about declarations is overwhelmingly made out by the general law, so that when my learned friend Mr. Hancock says in his skeleton, this is a novel and developing area of law, no, it isn't. It's a well-established area of law, and it's only developing because he wants to develop it in a way which is completely inconsistent with the way that declarations have developed hitherto. And his other argument, which I think may sound a little hollow for your lordships, is that the court hasn't heard full argument on the point. Well, you have now. And I think he put that in the context of his reliance upon Ultimo and there's other cases where the House of Lords and the Supreme Court have said there should be judicial restraint, not on a jurisdiction case to engage in too much inquiry. But sometimes it's appropriate. It was said by Lord Collins in Ultimo, it's akin to Order 40, Part 24. But we all know that there are many Part 24 applications where pure points of law are now argued. So there is nothing inimical about arguing a point, giving it full argument, when it is appropriate to do so. Clearly, in many, many jurisdiction, serious issue to be tried cases, it is not appropriate to spend an necessary period of time going into points of law. That's true. And certainly, as Lord Collins said in Ultimo, it shouldn't engage in a mini trial where there are issues of fact which might themselves have some sort of impact upon the determination of the issue of law. That is not this case. There is no question of fact. All that, the only questions of fact which arise in the judgment and awards claims are those identified by Mr. Hancock, which are going to take up a week of commercial court time next year, which is about Spanish law, which may not be of any relevance at all if the issue as to what is the impact of the declaration as a matter of English law is determinative of the entire thing. So I'm going to urge your lordships to take this particular bull by the horns and decide the point which actually will obliterate both the award claim and the damages and the judgment claim, because there is just simply no serious issue to be tried. And you'd be doing everybody a favour. There is no black hole, because there is still the Section 18 application. And the Section 18 application has the potential for creating a black hole only if there is Section 9, or rather a Section 1 immunity in the state. But if there's a Section 1 immunity in the state, then by definition, all of the claims will fail. So my learned friends holding out the Damoclean black hole is, if I may respectfully say so, not right. And I hope I accept, or I'm keen to accept, that the serious issue to be tried point arises only in relation to the awards claim and the judgment claim, not the Section 18, which is quite distinct and limited to one of jurisdiction. So I was going to show your lordships the relevant cases, but I do not think there is any need, and I can actually speed on. There are only two cases that merit some mention that my learned friend, Mr. Hancock, has relied upon, and Miss Dilnot has alluded to. Those are Berkeley and Windy Nook and Germain. And if I may be fairly quick with dealing with those, I make, your lordships will have Berkeley well in mind. It's at C1 tab 8. And for your lordship's reference, the decision itself was overturned by the House of Lords in a case glorying with the name of Bellshill and Moss End Cooperative Society against Dalziel Cooperative Society, which is 1960 Appeal Cases 832. So the actual decision has been overturned, but the point upon which Mr. Hancock relies wasn't. Now, it is important just to have a look at page 6 of tab 8. Because we can see that the claim there is in the middle of the page. This was, I think, adverted to by my Lord Justice Popplewell. And the last paragraph is almost a tail being added onto the donkey. The plaintiffs also claim damages and interest. And the defence, which is identified, is in the items of defence. The 7 arguments of defence are set out in the following paragraph. Now, I'm not asking you to look through them all now, but the one defence which was never made was there is no right to damages and interest. And that is because the point was never argued before Mr. Justice Streatfield. The report, as the page 7, halfway down, identifies dealt with 3 specific defences, the 4th, 5th and 7th. And when you go through the judgment, you will see that that is what the learned judge addressed his mind to. The point in the case was that there was an injunctive aspect of the declaration that was made by the arbitral tribunal after the remission to them, which was, broadly speaking, thou shalt not do business in certain parts of Manchester. And by definition, they did do business in those parts of Manchester. They did solicit trade. And that's why when one gets to page 19, the last 2 paragraphs of the judgment, what Mr. Justice Stretfield said was, in the result, the plaintiffs succeed in this action are entitled to the declaration asked for. With regard to the claim for an injunction, it was argued by Mr. Gardner on the authority of Davies and Davies that the terms of the award are too vague to be enforced by injunction, but the facts of that case were very different. And in my view, the words of the award are sufficiently specific to be enforceable by injunction. Now, but for the next paragraph, the case would have had no relevance at all to my learned friend or indeed to Mustell and Boyd. And what Mr. Justice Stretfield said, accordingly, the claim for an injunction will also be allowed as prayed, and I shall direct an inquiry as to damages. So it hadn't been the subject of argument, and all he did was direct an inquiry as to damages. And it is on that last point, which was not the subject of argument, not the subject of rationalisation by the learned judge, that my learned friend's entire case is founded. Now, it's entirely justifiable on the basis that it was an injunction, and there are occasions when, my learned friend Miss Dilnot has said, there are occasions when there may be damages for breach of an injunction. Just as there may, on occasions, be damages for breach of an undertaking to the court, as in the Milestone case that was relied upon, I think, by Mr. Hancock. But it's that one line, that half sentence, which is where my learned friend pins his colours to the mast. In my submission, there is absolutely no substance. When there was no defence raised, there was no reference in the judgment that the award was declaratory at all. The award was, in fact, tantamount to an injunction. Thou shalt not do canvas business in the particular area. And the court appears to have treated the award as enforceable as an injunction. So it really, really doesn't help him. And indeed, we don't know what happened on the whether there was an assessment of damages, and if so, what happened. It may be that... So it is a very, very limp proposition to be derived from the tail end of an unargued, unreasoned point by a first instance judge. In my submission, that's a very bad basis for his case. Now, dealing with Germain and Eaton, my learned friend makes a point. He says, well, there is no power under the law of the People's Republic of China to grant specific performance. And thus it was not, the award in that case was not an order for specific performance. As Miss Dilnot has pointed out, the provision of the law in the People's Republic of China made it perfectly plain that there could be an order for continued performance, and that is, by any stretch of the imagination, similable to an order for specific performance, and thus coercive. Now, the point arose in the Court of Final Appeal, which was a very, very arcane point. And it was about constructive trust. And that's where the character of the arbitral award became of potential importance. And it's in tab C4, tab 45. And the point arises, or arose, in this way. And I hope I hope I can summarize it adequately and then just show you where it's dealt with in the judgment of Lord Sumption. The action was brought not in China, but in Hong Kong, which was, at least then, it had its own independent legal system. Now, it was brought in Hong Kong because that is where the defendant company was incorporated and where its shares were issued. And different principles applied under the law of Hong Kong from the law of the People's Republic of China. And there was a question as to whether there was a constructive trust of the proceeds in Hong Kong based upon the old principle of equity, that where certain forms of contract, characteristically contracts for the sale of land or for unique property, once contracts of that sort are made, then the buyer acquires an interest as a constructive trust of any proceeds, because equity treats as done that which ought to be done and would specifically perform the contract. So there is an equitable interest arising as a result of the constructive trust. Now, in order for that to work in the law of Hong Kong, the law of Hong Kong had to recognize that there was effectively such an interest. And that meant the law of Hong Kong had to characterize whether the order made in China would itself have become an order for specific performance in Hong Kong. So what Lord Sumption did was, he said, well, the law of Hong Kong, in answering that question, has to look and see what are the characteristics of the order in the People's Republic of China, and then ask itself whether those characteristics would themselves justify an order for specific performance in Hong Kong. And he looked at those. He said the characteristics are such that there would not have been an order for specific performance in Hong Kong because there were too many conditions that had to be performed before the specifically performable obligation could arise under the law of Hong Kong. And thus, the constructive trust argument failed. So that's, I hope it's set out, it's in paragraphs 174 to 180 of the judgment of Lord Sumption. But I hope you can see that the way in which it arose, the point arose, was absolutely not to do at all with whether the order of the arbitrator was coercive and was in effect an order for specific performance, but it's just that in the particular circumstances of that case, the specifically performable characteristics under the law of Hong Kong would have prevented it and therefore prevented the creation of a constructive trust.
I've just realised I don't appear to have all of Lord Sumption's judgment.
Oh.
My copy, at any rate.
That will be...
ends at page 402 and jumps straight to 413.
Oh, well, that will be remedied. But
My Lord, I think what happened is the judgment was so long, the parties, to save space, took out the irrelevant material because there's so much
Yes.
of it. But
it's become the relevant material because of the way that my learned friend Mr. Hancock has characterised it.
It's become the critical paragraph.
Yes, we will.
Thank you very much.
I'm sorry I've gone into such detail because it's in order to understand how the point arose, you've got to understand, or rather, to understand what the Court of Final Appeal thought about the case, you have to understand why it was relevant and how it arose. And it was, for what it's worth...
But I think we can see enough from the bits I have got as to what the award actually...
Yes, well, I'm grateful.
I think we have it all electronically.
That's true, yes.
Yes. I believe so. But in any event, I hope I've given you enough help as to what the Court of Final Appeal actually thought was critical on the
Yes.
coercive aspect. So I think, having dealt with Berkeley and Germain, and having made such propositions as I can, I'm otherwise going to rely upon everything that Ms. Gilnoff has said, and I hope that what I've added has at least added something useful. Probably not. There we go. Unless I can assist you further on that, the serious issue to be tried on the coercive effect of declarations. On the issue of subrogation and injured parties, as I've indicated, we set out our case in the skeleton argument, and I would refer to that. One has to remember that one of the underlying and dominant principles of the relevant European legislation, whether it's the Recast or Brussels I or Brussels Reg before it, is the avoidance of fragmentation, if at all possible. The regulations are designed to avoid, where possible, irreconcilable judgments, which can always happen if you have the same point being decided by two parallel jurisdictions. What the enforcement provisions of Article 37 and following do is to say, in the rare occasions, we hope rare occasions, where there are irreconcilable judgments, we hope we've avoided that, then the answer is as set out in the regulation. But we'll try and avoid irreconcilable judgments. Now, one of the points that necessarily arises from my learned friend's argument is that if you split off subrogated claims from non-subrogated claims of an injured party, then almost by definition, you are creating the circumstances in which there could be irreconcilable judgments on precisely the same cause of action. And that is what Mr. Justice Butcher rightly recognised was unacceptable in the European context, and why he said there should be no difference as to whether there was a claim qua subrogee or qua direct injured party. But one
Is that not inherent in Article 14 anyway? What happens if you have a group policy in which there are assureds who are domiciled in different countries and the insurer wants a declaration of non-liability? Looks like Article 14 requires him to go to each of the separate domiciles separately.
That is possible, my lord. And as I say, the main object of the regulation is to try to avoid irreconcilable judgments. It's not always that it's going to succeed, And it may very well be that if the insurer who wants a declaration of non-liability, then he may well have to go to a number of different places. That is in the situation that you've envisaged. But he's encouraged. What he can't do is to say, as a result of the fact that I might, in certain circumstances, have to go to courts that I don't want to go to, what he can't do is go to a court that he does want to go to, which isn't otherwise permissible. But what your lordship has said is utterly right. It may very well be that they could end up being irreconcilable judgments, but and then that's dealt with then under Article 37 and following as to how it's dealt with. But the point, the underlying principle is that you shouldn't go out of your way to create fragmentation. But that rather assumes that the claim of a subrogee in the position of the state, like Spain, is not actually made by Spain as an injured party. It's only the nature of the injury that has been suffered. The injury can be suffered either by inflicting damage upon the territory of the Kingdom of Spain, or it can be done by inflicting damage on the citizens of the Kingdom of Spain, who by definition are all going to be in Spain. And it may very well be that each of them has their own claim against the club. But in fact, what has happened is Spain, acting as a responsible government, has sought to keep its citizens safe and has simply taken a subrogation of the citizens' individual rights. But Spain has suffered the loss. It is still an injured party. It's just that it's more indirectly injured than simply by virtue of being the state in which the territory, the physical land is to be found. But and it's also an odd characteristic that because of the particular domestic Spanish way that subrogated claims are advanced, I think one will remember that there are a number of states around the world where subrogated insurers have their own claim qua subrogee. I think actually the Front Comore was just such a case. But others, such as England, where the subrogated insurer sues in the name of the injured party. So the result would be, so let us suppose that the injured party has suffered, is an injured party for the purposes of the regulation. And in England, the injured party's claim would be advanced in the name of the injured party. Then this point wouldn't arise. It's only because the subrogee gets a personal cause of action effectively for the subrogee's loss. It doesn't alter the fact that the underlying claim is that of an injured party. So, in my respectful submission, the learned judge was right. You should avoid fragmentation if possible. But in any event, Spain was an injured party in respect of the subrogated and non-subrogated claims. But even if that were not right, the non-subrogated claims would be for some still in excess of $1 billion, because as has been pointed out, the total loss was 2.3 billion euros. And even on my learned friend Mr. Hancock's best case, still most of that, what in English political terms would be called the overwhelming majority of that, was sued for by Spain, qua Spain, as a distinct injured party. So, in my learned friend's submissions that somehow you shouldn't have to cavil about how many claims there are and what's their quantity. If there is a single compendious claim by a party which has suffered injury as a result of a relevant insured liability, then it should be able to act as if it was an injured party, and the subrogation point is of no value. The next point, and we're doing well, counterclaims. Now, one needs just to remember that there are different contexts in which counterclaims, in inverted commas, arise before your lordships. There is counterclaims for the purposes of state immunity with regard to submitting to the jurisdiction of the court, for the purposes of Section 2. And then there is counterclaims in the European context. Now, counterclaims in the state immunity context are counterclaims as expressed in an English statute. And an English statute might be expected to treat counterclaims as understood in domestic law. But we're not concerned with that. We're concerned with counterclaims in the European context. And as has been said, it is an autonomous concept, must be an autonomous concept, and it was not dependent upon the individual procedural characteristics or oddities of individual nation states. So one is looking somewhat above it. Now, a moment's reflection will reveal that this argument actually does Mr. Hancock in completely, for this reason, that it is said that the enforcement application, the enforcement under the convention, can generate a submission to jurisdiction which will then permit, in separate actions, things which are properly to be viewed as counterclaims. Now, the whole point of the enforcement provisions of Recast is to make enforcement quick and simple, and with very few exceptions, which are specified in Article Article 45, which is in B1 tab 2 for what it's worth, under Section 3, refusal of recognition and enforcement. And there are specific grounds for refusal, which your lordships will be familiar with: public policy, default of appearance, and irreconcilable judgments. Now, if my learned friend Mr. Hancock is right, what a party can do is sit back, allow judgment to be entered, albeit in circumstances which are not covered by paragraph B, where there's no sufficient time to enter an appearance. It intentionally sits back and does absolutely nothing, as the club did in this case quite plainly, given that it was also supporting its members. Let the judgment get entered by doing nothing, and you might be used to know that that was the reason why the Supreme Court actually did enter judgment, was because the club didn't present any defence. And then, when it comes to be enforced in England, they can say, well, we can start our own actions, which will completely undo any enforcement. And although they are our own actions, they will be treated as counterclaims for European purposes, which will then defeat the simple enforcement or recognition and enforcement of a member state judgment. And thus grind the whole thing to a halt, necessarily, because the avowed purpose of the claim is to defeat enforcement. So what my learned friend is saying is that if you give counterclaims a proper European meaning, an autonomous meaning, then by definition, there is a further ground of avoiding recognition and enforcement, which can be raised by way of a counterclaim. My submission. What he is saying is utterly inimical to the whole structure of the regulation.
Isn't it really as simple as this, that when Article 14.2 says a counterclaim in the court in which the original claim is pending, it means in which the original claim is pending and not the enforcement of the original claim is pending?
Yes, yes. Actually, that's a good point, yes. But,
and that's essentially the judge's point.
Yes, yes. Well, yes, and I'm going to leap onto it as well. But whatever it is, it's not counterclaim which is embodied in present judgment and award actions. That's my submission. And to say there's got to be an autonomous meaning actually proves exactly what it proves far too much for my learned friend. The fact is that also, so far as it were, the process of enforcement is by way of registration, and then if there is a desire to avoid enforcement, there is then an appeal. So the quotes counterclaim is by definition a counterclaim in my learned friend's own appeal. Now, that's not just a question of English domestic procedural oddity. That is the way that the European regulation works. So what he has to say is that a completely different set of actions, unrelated by any proper procedure to the enforcement, can become autonomous counterclaims in their own appeal. But apart from all of that, there's one thing that has happened in this case, is that my learned friend has not sought to make these claims, the judgment and award actions, counterclaims in the enforcement. So it may be that they might have been, I don't think they could in the context of the European regulation, but they haven't. So whether it's plum or duff, the proof of the pudding lies in the eating of it. So, my lord, that deals with counterclaims both in the context of Article 14.2 and in the context of Article 8.3. And 8.3, of course, arises in the context that we aren't talking about a matter relating to insurance, which brings me to my last point. And for once, I'm going quickly. And that is that if it's not a matter relating to insurance, and it's not a matter relating to contract, for reasons we've already gone into, and Miss Dilnot has I'm trying to find the right adverb, but has explained. I was going to say admirably, but anyway. Section 2 of Brussels Recast is claims in tort, delict, and quasi-delict. I accept for what it is worth, that so far as the autonomous meanings of the regulation and the European law are concerned, tort, delict, and quasi-delict have an extended meaning as a result of the Phillips case. But at the same time, one has to remember that it is still dealing with concepts which are familiar across all the systems, which is tort and delict, whichever way you refer to them. What it is not doing is saying that there may be discrete domestic causes of action which are entirely of a national foundation, not recognized across the panoply of Europe, which may give rise to causes of action which may thus fall within 7.2. And I rely upon the fact that my learned friend's entire case is founded upon a discrete domestic principle of equity, which is not found elsewhere. But let's suppose for the moment that he is right and that it might come within Article 7.2. Because otherwise he would have to show that there is a contractual obligation to abide by a declaration. There is a tortious obligation to abide by a declaration. There is a statutory reason for abiding by a declaration. The statute is the Arbitration Act, which doesn't arise in this context. And there is an equitable reason for abiding by the declaration. Now let's suppose, for the moment, that one or other of those otherwise falls within 7.2, which is quite a big stretch. You then have to ask, where is the harm suffered? Now, my learned friend has suffered no harm at the moment in the form of payment of money. Indeed, he's trying to avoid that very thing by his actions and his arbitrations. What he has suffered is a liability. And the liability is a liability in Spain. Now, in a sense, one may see analogies. And these are domestic analogies, so they have their limits. With limitation, the Limitation Act, not limitation actions. The limitation in the case of, let's just say, accountant's negligence or solicitor's negligence or professional negligence. And characteristically, where an item of negligence has caused a liability to be incurred, that is what establishes the cause of action, and that is what sets time running. And your lordships will be familiar with all of those cases where limitation is raised as a defence. Now, it is the liability, not the establishment and the paying of the liability that matters for those purposes. That's where the loss is suffered. And that is completely consistent with the AMT case, which my learned friend has still not showed you. There, the damage was suffered, the loss was suffered in Germany, even though the breach of contract that was alleged to have been induced occurred in the UK. So the harmful event is, and the only harmful event at the moment, is the incurring of a liability in Spain. And that's where Article 7.2 directs judicial attention.
Well, I think there's also, in fact, a claim for the costs of defending the Spanish proceedings. But
which by definition have been incurred in Spain. Yes, I mean, they've been incurred in Spain. It maybe they've been funded by people writing the checks in London, but they've been paid, or should have been paid, in Spain. So that, in a sense, is just a much more real example of where the loss was suffered. I mean, that is currently the only financial loss by paying Spanish lawyers in Spain. So, if Article 7.2 is relevant, and there are a lot of hurdles that Mr. Hancock has to surmount, then the harmful event was in Spain, and this court doesn't have jurisdiction in that region, or didn't have jurisdiction at the relevant time. I can't think that I have anything further to add, but may I just inquire of my learned junior, who is far more versed in these things than am I. Passed under the withering scrutiny of both Mr. Hamlin and Miss Dilnot, apparently there's nothing further that I can add. So, unless I can assist you further in answering any questions.
Could I ask you, I raised the question whether or not the entry of an English judgment and the enforcement of it could, in any event, be regarded as a harmful act. Is that the point you adopt, or is...
Oh, well, it's one, in a sense, I thought I'd made almost at the very beginning, that it's by definition it is by definition a lawful act, and it can't be. But so, yeah, I mean, yes, to the extent that I haven't already adopted it, may I certainly adopt it now, my lord, yes. I thought that I was going to be saying everything else is set out in my skeleton argument, and I don't need to, if I was getting close to 1 o'clock. It still is all set out in the skeleton argument at rather greater length than I've done.
All right, we understand that. Thank you very much.
Unless I can assist you further, those are my submissions.
Thank you. Yes, Mr. Hancock.
Well, might I just start with Lord Justice Phillips' question just now, which also goes to the Alexander T that Mr. Young addressed you on, though you haven't looked at it. I would encourage your lordships not to say anything at all about that issue, as in the argument that the entry of a judgment, even if wrongfully obtained, cannot give rise to harm, because that is an issue in the arbitrations, which on any view, your lordships are essentially, unless you effectively strike out the Section 18 applications, would be still ongoing. And I would encourage your lordships not to express any views which are in truth views on the merits of the state's claims, which might actually be fastened upon in the context of the arbitrations which are ongoing. The reason why Mr. Young mentioned the first reason is not a point that is, in my respectful submission, critical or crucial to the questions for your lordship. Your lordships, I do submit that the entry of a judgment which should not have been obtained at all is harm. The entry of a judgment which causes loss to a party is certainly harm. Whether or not actually that judgment is rightfully or wrongfully obtained is a separate question. There's a distinction between the question of breach and the question of loss, and the entry of the judgment goes to the question of loss, not to the question of breach. So it's very important to distinguish between those two elements of the inquiry. My Lord, if I can then go back to the regulation in the context of the award claims, and your Lordships will recall that you were addressed yesterday on the relevance of the Assens-Harman decision, because it does now appear to be the case that the states rest their entire case in relation to the regulation and its applicability or otherwise to the award claims on the Assens-Harman decision. I still made that quite clear very fairly yesterday.
Yes.
The only reason for my saying anything further is because you will see in the state's argument, skeleton argument, reference to a passage from Arnold, in which the learned editors of Arnold express the view, without actually explaining why they express this view, that Assens-Harman would actually cause problems in the context of an arbitration agreement. There's also a paragraph in an article by Professor Murphy in the Insurance Law Monthly, which the club has, which the states have referred to. Conversely, just for your Lordship's note, then Professor Briggs's textbook, which is at B2 tab 34, expresses the quite clear position, paragraphs 905 and 12.12, that the regulation...
905 and 12.
And 12.12, my Lord. That the regulation has no application to arbitration agreements, and therefore Assens-Harman doesn't actually impact on arbitration agreements at all.
Yes.
I wasn't proposing to take your Lordship to those sections now, it was just for your Lordship's note. The next point, my Lord, is in relation, still on the award claims, is in relation to declarations. And your Lordships have now heard from my learned friends a great deal of argument on declarations. Your Lordships know my starting position on this, which is that the question is not what should be determined on a jurisdictional hearing such as this, by virtue of all of the dicta in cases like Lungau and Vedanta and Ultimo Holdings. And that is particularly so because, in my respectful submission, then the point is one which is in development. And your Lordships will recall that the courts are encouraged not to determine questions which are in the course of development on Order 14 applications, a fortiori, therefore, jurisdictional applications. And your Lordship won't need me to remind you of the statement of principles applicable to Order 14 applications most commonly recited in front of first instance judges, which is the statement of Mr. Justice Lewison, as he then was in the Easy Air case, where he refers to the decision of the House of Lords in, I remember the name of the case, but it was a local authority case.
Three Rivers. Three Rivers?
It isn't actually Three Rivers, but it is a local authority case which, in which that proposition was put forward.
Yes.
As to whether it's an easy or difficult point, perhaps if I can take this firstly from our learned friend Mr. Young's very helpful note, which I saw for the first time this morning. And the logic of our position is, as your Lordships know, that the start point is that the underlying obligation is that set out in the contract itself? That is the obligation to arbitrate set out in the contract. Or, as my Lord Justice Phillips has corrected me on a number of occasions, the obligation, if a claim is to be made, it must be arbitrated. That being the underlying obligation, the next question is, does the fact that that obligation has been embodied in an award add anything to the underlying obligation? And in my submission, as your lordships know, and I'm trying not to repeat myself in reply, but the answer to that question is yes, because there is an implied promise separate from the underlying obligation, a la the bombasti, and a la the Hong Kong Court of Final Appeal case approving the bombasti and the principle laid down in the bombasti, that there was a separate implied promise by virtue of a reference to arbitration to adhere to the obligation then stated in the award. And if the award states that the underlying obligation is to arbitrate if a claim is to be made, then in my respectful submission, then bombasti and the Hong Kong Court of Final Appeal establish that there is a separate promise by virtue of the matter having been referred to arbitration to do that which the arbitrator has declared must be done, albeit that the arbitrator is simply stating what the contract had already required to be done. So that fundamentally, and again, if one starts from the simple proposition of a reference which is made consensually, let's say where there is actually a dispute between the parties as to whether or not there is a binding arbitration obligation, and that dispute is referred to an arbitrator, and the arbitrator decides that dispute in favour of the proposition that there is a binding arbitration obligation. In one sense, the arbitrator is simply declaring that which the contract already stated, but because the parties have asked the arbitrator to state what their rights and obligations are, and because of the implied promise to accept and abide by the decision of the arbitrator on that question, there is then a superadded separate obligation imposed upon the parties to arbitrate. In one sense, it is, as I put it, a restatement, but it is, in another sense, the product of an independent reference giving rise to an implied promise to do that which the arbitrator determines has to be done. And that is irrespective of whether the arbitrator's order is in mandatory or coercive terms. The arbitrator has simply determined the dispute, and the parties are bound by that determination, and implicitly promise that they will abide by the decision that the arbitrator has made. Our case is really as simple as that, and in our submission then it is supported by the authorities to which I've taken your lordship, the bombasti, the Aegis case, the Hong Kong Court of Final Appeal case, and the Amazon reefer. The point that our learned friends take, that's to say that a declaratory judgment has no teeth at all, it has no meaning, is, with great respect, I would submit, ill-founded, because what it does is it is, as its name suggests, a declaration of right. The mere fact that the right that it declares declares already existed does not mean that the determination by the arbitrator that that is the case is itself a meaningless one. It is one which the parties have promised to accept and to abide by. And as such, it carries with it an implicit promise which is separate and additional to the original right.
Well, they don't say it has no teeth. They accept that it has preclusive effect, and subject to their point about the regulation, which is going to be the subject of a later appeal.
Yes.
They would accept it gives rise to an issue estoppel and would prevent
well, they do,
enforcement of
although,
any
as your
other.
lordship knows, in a different context, they say even though it does give rise to an issue estoppel, they say not as regards the claim the club wishes to bring. So they say that although it's been suggested to you that the proper forum for these disputes should be before the arbitrators, as your lordship knows, and indeed said, I think, yesterday, they don't accept that the proper forum for these disputes is in front of the arbitrators, because they say that the arbitrators don't have any jurisdiction in relation to the club's claims. So they do say that these claims, because that's the point, my Lord Justice Popplewell looks puzzled. That's the point about the suggestion that although they are bound to arbitrate their claims, they're not bound to arbitrate the club's claims for breach of the claims to arbitrate their claims. So on the state's case, yes, actually, these claims do fall into a legal black hole, because they say that the arbitrators don't have jurisdiction to deal with them, even though in relation to these two claims, they say the proper forum is the arbitral forum and not the courts.
Another way in which it might be put is they have abided by the decision. The decision is that they're under an obligation not to arbitrate elsewhere, not to sue elsewhere. They accept that they are bound by that as a determination of what their obligations are. They simply say we're choosing not to perform them.
Yes.
And so they've abided. They have abided by the decision,
Well,
and choosing not to perform the obligations wasn't the subject matter of the decision.
well, it was, my Lord, because I go back to the use of the word must. They were told they must make their claims in arbitration. What has happened is that they haven't made their claims in arbitration. So, again, I would respect it's a misuse of language to say that they've abided by the decision, but they've chosen not to do that which the decision stated that they had to do. Effectively, they're having their cake and eat it, putting it colloquially on that use of language. And I would submit that that's clearly not something which is or should be open to the states.
Right. Is that a convenient moment, Mr. Hancock?
It is, and I'm hoping that I will be a great deal less than the hour that I said.
All right. Well, we live in hope. 2 o'clock.